Welcome. My name is Jasleen Coley. I am the director of the Critical Race Studies program, and I want to welcome you all here tonight. Thank you all for coming. First, before we get started, I want to also thank our co-sponsors. The following organizations have sponsored this event as well, and we thank them for all of their help and support. We have the American Constitution Society, the Asian Pacific Islander Law Students Association, the Black Law Students Association, the Criminal Justice Society, the David J. Epstein Program in Public Interest Law and Policy, La Raza Law Students Association, the Muslim Law Students Association, the National Lawyers Guild, and Outlaw. And with that, I will be turning it over to Professor Kimberly Crenshaw. Professor Crenshaw really needs no introduction, but I will give her a brief one, which will in no way do justice to her vast body of work. Professor Crenshaw is Distinguished Professor of Law here at UCLA. She is a leading authority in the area of civil rights, Black feminist legal theory, and critical race theory. Her articles have appeared in the Harvard Law Review, the National Black Law Journal, the Stanford Law Review, and Southern California Law Review. She is the founding coordinator of the Critical Race Theory Workshop and the co-editor of the volume Critical Race Theory, Key Documents That Shaped the Movement. She teaches civil rights, intersectionality, and courses addressing transnational dimensions of race in the law. So thank you so much, Professor Crenshaw, and I will turn it over to you.
Thank you, Jasleen. Good evening, everyone. So some have called the killing of Trayvon Martin the Emmett Till of the 21st century. While the issues of the cases are, of course, different, in one, the ostensible question was whether the defendants killed anyone at all, and in the Trayvon Martin case, the issue was whether the killing was justified. In reality, both cases raise questions about whether the killing of a black boy who is seen as by defendants as constituting a threat would be punished or permitted. Certainly, of course, the threats were different. Till violated codes of black performance with a flirtatious engagement with a white woman that was perceived by whites to be a threat against sexual security. And in the Martin case, the racial contours of Trayvon's transgressions were wrapped around his movement as a suspicious character, out of place, furtive, aggressive. Yet in both, something they did that was not life-threatening became a rationale for death. The wolf whistle spelled Till's fate. The weaponized sidewalk marked the tragic end for Trayvon. This case has galvanized Americans concerned that a black teenager could be completely innocent of any criminal wrongdoing and yet justifiably dead at the hands of a self-appointed patrolman. At the same time, for many other Americans who hope to put the case behind us, the controversy is nothing but the latest episode of racial grievance. Now, this yawning gap between these interpretations not only forces us to confront the extent to which claims around post-racialism are premature, but also forces us to confront the fact that there is a chasm in understanding about the central ways in which race is experienced, structured, regulated, and performed in our society. So this case has become a template from which to read all of the ways that race continues to be mystified in contemporary America. Key to uncovering the numerous misunderstandings that have circulated in the aftermath of this case is law, social science, and history. So we're fortunate to have assembled this stellar group of colleagues to help us better understand what the case is telling us. We have among this group, all part of the immediate and extended UCLA family, an advocate and litigator who specializes in policing and privacy, a former prosecutor and public defender and now social scientist who specializes in criminology and psychology, a criminal law critical race theory scholar who focuses on law enforcement and juvenile justice issues, and an award-winning, internationally recognized historian, social justice commentator, scholar, and activist. Now, I don't want you to keep guessing as to who is who, so I welcome you to consult their fuller bios, which are in your program. But for now, please help me welcome Peter Bibring, Sherod Thaxton, Addie Rolnick, and Robin Kelley. So there's a week-long conversation that we could have about the Trayvon Martin case itself. Add to that the closely connected issues of racial profiling, the landmark holding against New York City Stop and Frisk campaign that happened a few months ago, the wider concerns about the expansion of criminal law, the punishment industry and its privatization at both the institutional and private level. There's both the constitutional and criminal law to be examined, the social psychology of juries and race to be explored, the construction of race, threat, and justification in the media to be interrogated, the performance of lawyers, judges, commentators, activists, and the president himself to be critiqued, and importantly, the long, long history of struggle against state and private violence to be mobilized and lifted up, and all within 90 minutes. So buckle up. So we've structured our time here as a roundtable conversation rather than a panel of self-contained presentations. We've conversed and we've raised several points of departure, and we've agreed to confine opening remarks to 5 minutes or less in response to specific questions touching on some or all of these issues. These may be followed by further elaborations, either immediately following the open remarks or later in our conversation. Now, we have a general idea of where we're starting, but the destination of this conversation has not yet been set and will take shape in the interaction of the roundtable and subsequently in the roundtable's interaction with you. So, let's jump in. I'm going to start with our current practitioner on the panel, Peter. So, Peter, one of the flashpoints around this tragedy is that many Americans, statistics say, by some measures, a majority of Americans, assert that race has been deliberately inserted into the Martin case, and in many others. One might say, to some extent, even the prosecution itself was hobbled by its inability to say what race has got to do with it. So how do you answer that question in the work that you do? Share with us some of the scenes from the work you do and explain what does race have to do with it.
Sure. Thank you very much, and thank you for having me and putting this together. It's very exciting. Well, I mean, I think the first point is that this disconnect between the two sides, the side that views the Trayvon Martin as being the trial, the incident, the arrest and interrogation, the police handling of George Zimmerman, the prosecution, the jury's verdict, and the reaction of the country as something that's fundamentally the criminal justice system working in its race-neutral way on the one hand, and on the other hand, the vast portions of the country, including probably everybody in this room, who sees this as stark evidence of a criminal justice system that's infected at every turn with racism. That disconnect is the disconnect that lies at the heart of nearly every important debate we have about the criminal justice system, right? Whether you're talking about the incredible disparities in incarceration rates, the disparities in stop and frisk that you mentioned a moment ago, the school-to-prison pipeline, right? The problem with advocacy in all of these regards is the idea that advocates for social justice see the racism so starkly, right? If you look at the facts of what happened in this case, you look at the disparities in stop and frisk in New York, and there is only one answer, which is racism. And the other side, which just sees race-neutral criminal justice system, race-neutral legal standards operating. And so the battle that all advocates confront is how to bridge that, how to convince the other side that, or whether it's policymakers, a jury, a judge, that race is something that is salient and has to be addressed. You know, and I in my own work, I see this most often in the stop and frisk context, working with LAPD and other departments, and trying to point to the racial disparities, which are overwhelming. And for those of you that aren't aware, there's been a lot in the news about NYPD, but in LAPD, the disparities are nearly as severe. And trying to convince policymakers, much less courts, that that's a problem that needs to be addressed. And for many years, we were stuck in this argument about whether it was obvious or not. And I think one of the things that started to emerge in the last 15 years or so due to new research is the idea of implicit bias. And it's not a very complicated idea, the idea that rather than intentional racism, what is happening in the criminal justice system is simply an unconscious bias that plays out in all our decisions, is something that's taking over. And that starting in 1998 with the introduction of research about the implicit association tests, which showed so starkly that Americans from every walk of life, progressives, conservatives, whites, blacks, all have associations between African Americans and criminality. And although those were initially shown in rather artificial kind of laboratory settings, their studies are increasingly applying those findings to more realistic criminal justice situations, and showing, and that explains how racism can infect the process, right? And the news is both good and bad, because first, policymakers can see that race can play a factor without condemning individual decision makers to a status as racists, right? When you go and advocate before the Los Angeles Police Department, before the Board of Police Commissioners, it is much easier to say, this is a problem that all Americans have, it's a problem that's society-wide, than it is to say your department is a bunch of racists, right? They're more willing to change their policies for the former than the latter. The bad news is, and just very briefly, that it's a nearly intractable problem to the extent that it infects broadly the American populace and infects every decision that's made in the criminal justice system. I mean, if you look at the number of decisions that are essentially discretionary, right? Whether George Zimmerman reasonably believed that he was acting in self-defense, whether the police reasonably believed that George Zimmerman was acting in self-defense when they decided whether to arrest him or charge him or how to interrogate him, the prosecutors in making the charging decision, the jurors in ultimately deciding their acquittal. And it's the same problem that infects the criminal justice system generally, whether there is reasonable suspicion for a stop or for a frisk, whether there's probable cause for an arrest, what the bail should be set at, what the sentence should be, whether parole should be granted, right? If racism infects every discretionary decision, then the system is in trouble.
Thanks, Peter. So that question about how racism and race may infect or shape discretionary decision-making takes us directly to the question of the jury. So, Sherod, I'm going to turn to you. So there was a lot of Monday morning quarterbacking about what went wrong in the case. For the most part, I think it's fair to say that the debate is less about whether the outcome was inevitable. Many people said that they thought it was inevitable, but why? So some stake their claim in the nature of self-defense law, which Addie will talk about in a minute, and others foreground the performance of the prosecution, questions about the decision-making of the judge. But very few actually talk about the jury itself, namely how the jury's constitution is made up, how that constitution influences decision making, and fewer of those people who even talk about that are willing to address the role that race may play in that decision making. So we've already heard a little bit about implicit bias across the great expanse of the criminal justice system. What do people need to know about the role of race in juries, either in the selection or, more importantly, what goes on in that jury room?
Okay, let me begin, I guess, by getting the microphone closer to me. Okay. Irrespective of your personal belief in the validity of the outcome of the verdict in the George Zimmerman trial, I think it's beyond reasonable contestation that when you have a jury that has zero gender diversity, no meaningful racial ethnic diversity, no meaningful age diversity, not only is that jury unrepresentative of Seminole County, the place where the case was tried, but also American society in general. So what I want to do is briefly, in my time, talk about the jury itself, and then why the composition of that jury is relevant. And I'm going to take two approaches to that. One, the general social science literature, and then also the relevance of racial composition of juries and the everyday practice of parties who are involved in jury selection. So I'm sure many of you were familiar following the case, but let me remind you with respect to the jury. So under Florida's system, there were 6 jurors, and initially 4 alternates in the Zimmerman case, but one alternate was dismissed shortly after the trial started. And but of those, then now 9 individuals, 8 were white. You had 1 male alternate, and then you had the 1 Hispanic, Afro-Latina in the main jury. Okay, so again, out of 9 individuals, you have 8 were Caucasian. Okay, with respect to the ages, like the age diversity, one of the jurors in her late 30s. Some of these are approximate because jurors' identities were kept confidential, but another juror in late 40s, 1 in the 50s, and 2 in their 60s. Okay, and then with respect to the alternates, you had 1 Caucasian male and a Caucasian female who were in their considered called middle-aged, and then the third alternate was a college student. Okay, again, so these are some of the basic demographic compositions of that jury. Now, interestingly, so Mark O'Mara, right, George Zimmerman's defense counsel, said, he openly remarked that it didn't matter that the jury was all women. Didn't specifically comment on the racial issues much, but it didn't matter that it was all women, only that the jury was impartial. Then we must ask ourselves, and this ties into some of Peter's comments, right, can we expect a jury that has very little affinity with respect to race, and also culturally, there's aged as well generationally, to be able to reasonably put themselves in Trayvon Martin's shoes that evening and try to ascertain what was reasonable, right, in terms of his thoughts and his behavior with respect to George Zimmerman's provocation. Okay, so then we have to think, does the composition really of the jury really matter with respect to the way deliberations occur in these contexts? So first, let me start with social science, because that is my background. Okay, when we look at the social science literature, one robust finding we have is that mixed race, and race is the primary focus of the social science literature. There are other ascribed characteristics, but race is the major one. When we look at this literature, what we find is that mixed race juries are much more likely to deliberate longer, to entertain opposing views and different perspectives, and also they're less likely to commit some of the common errors that jurors actually that juries typically commit in these cases, right? And there's a very robust empirical literature about this, right? When we think about jurors' receptivity to mitigation evidence, right? So going outside of the Zimmerman case, but just in general, right? What we find is that racial composition matters, and so when you have 2 to 3 non-white jurors in doing deliberations, again, they're much more likely to consider this mitigation evidence, right? And so that's that's just a brief overview of the social science literature. But one thing we understand is that this composition actually matters, and this literature emerges out of many different jurisdictions and off a longer time frame. So my time is running short, but the second thing I want to mention is actual practice. And what we know is that trying to get a jury in using race and gender and ethnicity as proxies, right, is an important job for parties when they're trying to get a jury that will be most receptive and sympathetic to their story. All right. There was a recent study conducted by the Equal Justice Initiative looking at 8 of the former Confederate states, and found that in some states as many as 80% of prospective black jurors were excluded from jury duty with ostensibly race-neutral challenges during the peremptory stage, and I'll talk more about the rules hopefully a little bit later. Right? And that's also very common in jurisdictions that are predominantly African American to have all white juries. All right. So not only from the social science literature, but also in terms of practice, what we're seeing is that the race and the composition of the jury and how different parties believe that influences deliberations is very important to understanding what's going on in the process and assessment of reasonableness. All right.
Okay, thank you. Thank you. So, Addie, that brings us to another claim about what the Trayvon Martin case suggests. And so in one conversation, really the problem is that Florida, it said, stands out as a particularly bad actor. And stand your ground, to extend an analogy, might be the bad actor's rope. So we'll talk about some of the nuances around the expansion of self-defense in a moment. But first, how does this particular frame, that the problem is Florida, the problem is their particular self-defense law, the stand your ground law, distort or underserve our understanding of self-defense law writ large? What does race have to do with that?
Thank you, Kim. So I think it's helpful to think of self-defense in terms of a core and then expanding out from the core. And we can talk about the expansions later, but I think it's important to see that race is actually embedded in the very core of self-defense law. So in that sense, it doesn't make a lot of sense to talk about whether race was in the case or out of the case, whether the judge said that should be considered or it shouldn't, because, as I'll explain, there's no way for it not to be part of a self-defense case, at least when 2 strangers are involved. So maybe if you're in first year criminal law now, but definitely if you've taken it, you should have some sense of self-defense doctrine. And for self-defense, you need an imminent threat. You need proportionality, meaning your force has to be proportional to the force that is threatened upon you. That means deadly force for deadly force. If you're going to kill in self-defense, it has to be deadly force. And then you need necessity. So there's no other safe option, usually including no other safe retreat. So in other words, self-defense when a stranger is involved is a split-second assessment about whether a stranger is about to kill you. And to figure out whether a stranger poses that kind of threat, you can really only rely on cues that are easy to see. Race is going to be an irrevocable part of the mix of those cues in any situation. We can't close our eyes and not see it. Race is also going to influence our best guesses about some of the other factors that we might rely on. So what we think someone is doing, whether we think we see a weapon, whether that person looks out of place in a particular neighborhood, all of that is colored by race, and it's also colored by gender. I don't get into the social science literature here, so several other panelists have touched on it. I will recommend, if you're interested in sort of hearing a little bit more about implicit bias and race and self-defense, there's an article by Phil Goff and Song Richardson called Self-Defense and the Suspicion Heuristic, and a book by Cynthia Lee called Murder and the Reasonable Man, both of which go into this in more detail. So that's the first piece of self-defense, is you have to have fear. And race colors whether you have fear and how you assess that fear. Now, there's a second piece, and the second piece is supposed to be the legal check. The fear has to be reasonable. This is where law puts in a level that's going to be a check against irrational people. So vigilante racists and other irrational people like that, the idea is that their fear wouldn't be considered reasonable, so the law would protect against that. But as Peter touched on, race matters at the objective level too, because we all share this certain level of bias when it comes to race and gender. As a baseline assumption, we're all more likely to think that black and brown men are probably up to no good, unless we see otherwise, and we all tend to think that white women, on the other hand, are probably not up to no good. So a cop, a judge, or a jury member is more likely to be able to sympathize with the fear of a black or brown man and to see that killing then as justifiable. Because remember, in self-defense, the fear doesn't have to be correct, it just has to be reasonable. So I just want to give you one sort of example story to explain how I think race fits into the core of self-defense, and that is you can take the contention that the case had to come out this way. So under the law and under the instructions that were given, there's no other way to come out besides to acquit George Zimmerman. And if you imagine a different person in the place of Trayvon Martin, if you imagine a white woman, like most of the people on the jury, on a dark street with a man following her in a slow car, you imagine that the man keeps following her even when she tries to walk away. You imagine the man gets out of the car and pursues her on foot. Maybe she can see his gun, or maybe she just guesses that he might have one. She knows she doesn't have a weapon, and she can't seem to get away from him, so she fights back in the only way she can. She tries to wrestle his gun away or subdue him enough that she can get away. If she ends up dead in that case, would a jury believe that he, the man with the gun who chased her down a dark street, was so in fear of his life that he had no choice but to shoot her? Is there at least a possibility that they could believe he was not, that they would think of her instead as the victim who was defending herself against a man who was probably trying to kill her? The jury's sympathy and its assessment of fear is how this case could have come out differently, even on the same facts, and all of that comes down to a question of race and gender.
Thank you, Eddie. So Robin, I'm going to turn to you particularly with that hypothetical that Addie just framed, because one of the interesting things about all of the post-acquittal conversation is how infrequent it was that anyone asked the question about what Trayvon Martin might have been thinking or feeling at that moment. So it was all about the reasonableness of Zimmerman's fear, and no discourse whatsoever among the main commentators about the possibility that Trayvon Martin might have at least a right to stand his ground against what appeared to be assault. So I wonder what you think more broadly about what that is telling us, just the absence of much discursive empathy for him, the inability to raise questions about how not just the law, but how the media and how the state continue to frame communities as criminalizable. What is this telling us? And, broadly, does my analogy, this is the Emmett Till of the 21st century, make any sense in that light?
Right, that's an excellent question, and it ties together a number of issues. Emmett Till and self-defense, actually, I want to address as well. Now, I've written about this question about whether or not Trayvon Martin had the right to stand his ground, so I don't really want to address that, but I do want to address this question of, both the kind of, as you said, the discursive empathy for Trayvon Martin as an individual. In other words, even those who support him and who kind of critique or critical of his murder still sometimes bracket the long history of constant state violence, vigilante violence, and everything in between that African Americans have been experiencing and other people of color since the 19th century. And if we compare Emmett Till, the only difference, the reason that Emmett Till and Trayvon Martin are comparable is not their actual murder, they're essentially a lynching, but it's the fact that people mobilized, that there was actually a movement that turned Emmett Till from one more dead black boy in the South or anywhere in the United States to a real iconic figure, an international kind of cause célèbre, because of people on the ground who mobilized. Now, if you think about what happened after Emmett Till, the Emmett Till case was surrounded by a real movement, a mobilization that in some ways was expanding, not contracting in 1955. And part of that movement was also armed self-defense. And I don't want to be too controversial here, but for African Americans in Mississippi, and this is documented in Akinyele Umoja's new book called We Will Shoot Back, which I would suggest everyone should read, armed self-defense was a long tradition in the South among African Americans. And in fact, not only is it a long tradition, but armed self-defense and counter-surveillance, of state violence and vigilante violence has long been established, and it kind of grew since the 1950s. And when you think about the kinds of organizations that were devoted to self-defense, what are their names? Their names are, the Community Alert Patrol, Deacons for Defense, Negro Militias, Cop Watch, the Black Panther Party for Self-Defense. In other words, self-defense was not doctrine in the sense that it was individuals standing ground. It was community-based, protection of a community. That's a huge difference. It's a big difference in terms of what they were actually up to, because we're talking about people who are living in a world in which the assumption that armed white men around you are up to no good, because that's the world they live in, of constant violence, the constant threat of violence. So armed self-defense was protecting an entire community, not an individual facing what's perceived as a reasonable threat. The problem is that those same communities who engage in forms of armed self-defense or counter-surveillance are seen as violent. So if you pick up any book about sort of the civil rights movement or Black Power or even Reconstruction, violence is embedded in those who are engaged in armed self-defense. They're the ones who are perpetuating violence, not the ones who are protecting themselves from violence. Right? So again, I suggest that book was very, very interesting. Finally, as time is short, and I know we've got to get to some other questions. One of the unfortunate things about the constant vigilant focus on stand your ground is that it assumes that the only response would be a legislative, legal, juridical kind of response. That if you could just fix the law, that would fix the problem. That certainly hasn't been the case historically. And we'll talk more about that in time, so my time is up. So thanks.
So Robin, I'm going to ask you to hold the floor for the second round, and we'll push it back in the other direction. So one of the questions that might be asked here is how a particular orientation towards African American self-defense not only was read as itself violent, but actually the state took on a particular role against those organizations. And it's also part of the history that's not being told or articulated. So I wonder if you might say something about not just the state at the local level, but the federal government
Yes.
with respect to organizations and the particular ways that these organizations were destroyed and disrupted. What's
Absolutely.
the meaning of that history?
That's an excellent question, and the very, very brief version is that going back to Reconstruction, the federal government has played a key role in either dismantling or attacking and jailing and imprisoning or surveilling those organizations meant to protect black communities. So again, the Negro militia is a good example. African American men armed after the end of the Civil War to protect their community. One of the compromises of Reconstruction was to disarm the Negro militias, and actually in the post-Reconstruction period to make it illegal for some, not every community, to own guns. And so we know that the overthrow of Reconstruction was a process of armed rebellion on the part of white people. That's how it was, armed rebellion against democracy. If you take the 1930s, same thing. Many organizations I wrote about in Alabama, for example, were armed. They engaged in forms of self-defense. In every single case, those who are protecting themselves are the ones who go to jail or are lynched. And then finally, the 1950s and 60s, we know the story of COINTELPRO. We know the story of so many people who are incarcerated. I mean, I won't go into this, but even the recent amazing story of Herman Wallace and the Angola 3, where he was finally released as a result of a decision arguing that the jury had excluded women from his trial, which is kind of amazing. He's about to die now, but the fact that those members of the Black Panther Party, even though they joined the Black Panther Party inside of Angola prison, the fact is they were part of an organization formed in part to do two things: surveil the police and police practices, and document that through surveillance, document what they saw as illegal and unethical police practices, and protect the community through armed self-defense. And so again, it's part of a longer process that turns people who are essentially victims into predators, into sources of danger and threat to the state and to security. So in some ways, Trayvon Martin's case comes out of that very, very long history that we have to sort of pay attention to.
So this takes us back then, Addie, to the further elaboration that you were going to offer us on self-defense. So Robin tells the historical story about how victims are turned into predators. Of course, the law is a site, one of the sites in which that happens. But how actually does it happen? How does it happen through self-defense, and how is it happening in ways that are expanding the costs and consequences of self-defense? So a lot of people talk about this around stand your ground. Is that the source of the problem, or is that just a small piece or a superficial piece of what you see as a broader process that we're undergoing right now?
Yeah, so I'm not sure what stand your ground means after this case. Before this case, stand your ground usually, when it's discussed, means specifically one piece of an expansion of self-defense law, which is, remember, it has to be, you have to have necessity, and one shortcut around that is a law that says even if you have a safe option for retreat, you don't have to retreat. And so that's kind of shortcuts the necessity requirement a little bit. It's pretty common, so at least half the states have it, and I think almost all states have a rule that in your house you don't have to retreat. So that's what I would have called stand your ground before this. After the case, I think it has come to sometimes signify the whole package of expansions of self-defense passed by Florida, and sometimes it's actually come to signify self-defense itself. So the idea that someone can or can't take advantage of stand your ground is actually a discussion about whether they can or can't mount a self-defense claim. So when I talk about it, I mean the first use, just the duty to retreat part of it. And I think the focus on it is sort of, it actually distracts from the larger picture. So there's been discussion about whether it figured into the case or whether it didn't, and there's been calls to boycott Florida until stand your ground is repealed, calls to boycott other states until stand your ground is repealed. And I think it's important to see, remember I said self-defense has a core and then it has expanding from the core. So the core is the idea that you have to have an immediate deadly threat. And you have to sort of reasonably assess that deadly threat. Now, there are all kinds of reforms, quote, reforms that states have passed, including Florida, of which the duty to retreat piece is only one of them. So there are laws. One that's very common is called defensive habitation. So it's the idea that you can kill a person who is breaking into your home even if you're not in fear of your life. So you just have to reasonably think that they're breaking into your home, and then deadly force can be used. It's also legal in a lot of states to kill to stop any forcible felony, not just a deadly assault. Many states also allow you to kill without retreating from a conflict, even if you could have escaped danger by walking away. So that's what I would call stand your ground. Florida has some other slightly more exceptional provisions. Florida law has, let's see, a provision saying that you can kill in self-defense even if you start the fight in Florida. So not all states have that. You can also kill to protect your car, just like your home. So you can kill someone who breaks into your car while you're in it. And what I think is maybe the most difficult piece of it is sort of a burden-shifting provision. So many states require that the defendant has to prove affirmatively that he or she acted in self-defense, whereas in Florida the prosecution actually has to disprove a claim of self-defense. So that's a pretty significant change. So first of all, stand your ground is not just, it's only one of many of the differences about Florida law, but you have to see it as one of a whole picture of expansions of self-defense law that has a pretty disturbing effect on space. So altogether, all of these expansions basically make it legal to kill people who threaten more than just your person, but your space. You can kill to protect your home, your turf in a fight, and even maybe your neighborhood. Laws like this, together with gun laws, they suggest that it's a right and a duty for people to protect their homes and their neighborhoods, and then they make it much easier to claim self-defense when they do so. They then increase the sense of safety, ownership, and freedom that some people feel in their spaces, especially in a place like a gated community, which is where the Trayvon Martin killing happened. But at the same time, they increase the vulnerability of any people who might be seen as suspicious or out of place by their neighbors. So remember what I said about race. In other words, the laws reinforce white ownership of certain spaces and then render non-white bodies more vulnerable in those same spaces. And you can see this dynamic at work, actually, in some of the juror interviews. So juror B37 said in one of the interviews that she would feel very safe with George Zimmerman patrolling her neighborhood. And several of Zimmerman's young black male neighbors, so other people who lived in the neighborhood who happened to be young black men, told reporters, if you look at the stories around the case, that they don't actually walk in their own neighborhood because they don't feel safe. So you have a very big difference based on race and probably also on gender about who feels safe where. And that's sort of the cumulative effect that the laws have.
So, Sherod, this now goes back to the jury, right? So we have a set of laws that effectively racialize communities in ways that create different consequences depending on who you are and make you vulnerable to mistaken identification or other forms of threat. And then the jury is in the position to make a decision which basically sometimes reproduces the very thing that happened. How does this come about? So first of all, is law responsive to, or does it facilitate precisely this racialization? And second of all, how is law, or how can it be made responsive to some of what we know goes on in the jury room?
Thank you. Excellent question. All right, so the first question, the first time around asked, how do we know? I tried to address, how do we know that race matters in the jury box? One thing I didn't mention, and I'd be remiss if I didn't bring it up, was there's also actually pretty robust evidence of prosecution training in order to exclude African-American jurors, and still under the law, right? So still under quote-unquote legally permissible ways, and again, training manuals and videos that actually train prosecutors, right, how to strike black jurors and then have ostensibly racially neutral explanations in their back pocket in order to survive any challenge to their use of that peremptory strike. So that's something I also want to mention. So I think a good way to think of it is, so the first time around I addressed, right, how you know race matters. And then I think this time it's very important to ask, how is it, all right? Now I mentioned the composition of the Zimmerman jury, and these juries are very common. And so the other question is, it's been about 140 years since the U.S. Congress passed the Civil Rights Act of 1875 that outlawed racial discrimination in jury selection. And so I think interesting questions to ask is, are we in the current state we're in, where we still have all-white juries, right? We still have jury selection that's based upon race, even though the Supreme Court is very explicit that this is impermissible. And so I think there's a couple of ways we have to think about the rules, right? And so let's talk about the rules briefly in the time that I have, right? So on the one hand, the Supreme Court says part of having an impartial jury, right, under 1/6 Amendment, right, having an impartial jury is that jury is comprised of a fair cross-section of the community. But that applies to just the general jury pool, but not the trial jury, right? Not the jury that actually sits right down and deliberates, all right, on these cases. So although the jury list has to be a fair cross-section of the community, the actual trial, so we see this again in the Zimmerman case, does not have to be. And then the protections, right, we ostensibly think the protections that are necessary to at least have that trial jury closely mirror the community aren't there, okay? And so, for example, under existing, right, Supreme Court precedent, as I mentioned earlier, you can't strike a juror because of race, ethnicity, or gender, right? And okay, that sounds like a good rule to have, but in practice, prosecutors can give any reason, it doesn't have to be persuasive, any reason that's race neutral or gender neutral or ethnically neutral, right? So strikes have been approved for jurors who they didn't like the way their facial hair was groomed, right? Or they didn't think they were intelligent, or they didn't like the neighborhood they were from, right? Even one juror was struck because of the fact that they defaulted on a school loan. So, right? And so that's the first thing, right? And the second, right? And then the court has gone further and said, well, even if a person exercising a peremptory challenge, all right, does mention a impermissible reason, they could still salvage that if they mentioned a permissible reason. This is under this dual motive or mixed motive analysis, right? I think 4 at this point, or 5 is the count of federal circuits have approved this. Several states, Texas has approved this, Illinois has approved this as well. And so then it makes the bar that we thought that the Supreme Court said, right, the bar to using racially impermissible practices, it's justifiable because it's making it as easy as possible for prosecutors to act in a racially discriminatory manner.
So, Peter, coming now back around to you. So we've heard about, and it's pretty much everybody has picked up implicit bias that you started us with, and have talked about the various ways that law facilitates this implicit bias. I guess the question would be, how has the law been responsive to the elevation of implicit bias? So we know it facilitates. Is there any dimension of law that we can look to be responsive to the fact that these are racially biased consequences? Or is the story a little less enthusiastic about law's ability to be responsive?
So, sadly, it's the latter. That was probably not a surprise to anybody. If everybody on this panel is attuned to this idea of implicit bias being potentially the problem with the current constitutional doctrine is that implicit bias is not recognized at all, right? So you have from the Supreme Court's holding in Washington v. Davis the requirement that to prove an equal protection violation you need intent to discriminate. And probably most directly relevant to the discussion of Trayvon Martin and the Zimmerman trial and racial bias in the criminal justice system is the one of the court's most extraordinary decisions, I think, in 1987 McCleskey versus Kemp, where, for those of you who are not familiar with it, anti-capital punishment advocates presented a study done by a statistician that showed that in Georgia an overwhelming determinant of whether somebody would be executed for murder was to some extent the race of the defendant, but to a much larger extent the race of the victim, and presented that evidence as grounds for holding the death penalty unconstitutional. And that argument was rejected, and was rejected in large part because the court, for several reasons. One, the court held that although there was powerful evidence to think that race played an extraordinary role in the dispensing of capital punishment in Georgia, there had been no evidence presented that in this particular case, in this particular decision, the decision makers had actually had any discriminatory intent, right? So that's one problem. And then in one of those moments of kind of the politician's mistake of speaking the truth, the court acknowledged that if they were, and this is, advocates in this case framed the issue not only as a 14th Amendment issue, but also as an 8th Amendment issue. The idea that to put somebody to death under this system would be a cruel and unusual punishment. It's an arbitrary and capricious method of putting people to death. And the court recognized that to accept this argument would be disastrous for the criminal justice system, right? Because it's not at all limited to capital punishment. The idea that you can't impose a criminal penalty because the criminal justice system is infected with racial bias would undermine the entire criminal justice system, and my goodness, we can't do that, right? So the court 2 points. So today, as an advocate who sues police departments and occasionally alleges racial bias, racial profiling, it is very hard to get a straight finding that officers engage. It's actually very hard just to get a finding that individual officers engaged in racial bias. I mean, occasionally I'll file a suit. I had a suit out in Moreno Valley about raids on African American barbershops, which obviously focused on African American barbershops. And during discovery, when we found out that the plan was called Operation Fade Out, right, there was some some indication that race might have played a factor. That case settled quickly. But when you're talking about a systemic issue, right, it's very difficult to get to the idea that there's not just individual officers, but a whole system is infected with racial bias. It's very difficult to prove intent. I just very quickly, though, wanted to note the kind of alternative, which is, McCleskey was a 5-4 decision, right? And Justice Brennan, writing for the dissenters, noted that it wasn't actually, it didn't have to be that way. It wasn't consistent with previous capital punishment jurisprudence, that the court had previously recognized that even if you couldn't prove that an individual defendant's sentence was the result of an arbitrary and capricious rationale, the exposure to an intolerable level of risk of arbitrary result was enough to strike down the system of capital punishment. And that provides, I think, a way of thinking about how constitutional doctrine could fulfill the promise of equal protection without intent.
So on that note, I wanted to go back to Robin's observation that much of what we're talking about it isn't just about the idea that a legal reform is going to solve this. This does have political dimensions to it, but obviously the political dimensions are also linked up to the court. A 5-4 decision could just as easily gone in a different direction had there been a sustained presence of votes that would have gone in that direction. So it's clear that law isn't just articulating itself. It's being articulated, and it's also a reflection of politics in the broader sphere. So on that note, sort of bringing the circle out a little bit further, I think there was a moment, and Robin, I'm not sure if you think it's past or not, when it appeared as though that the resistance and the outrage and the system's affirmation of the killing of Trayvon was going to lead to something sustainable, something that was going to make it hard to go back to business as usual. And then there was this moment when the president spoke, which I think a lot of people thought, there might be some disagreement here, that, okay, this is a watershed moment. And it was kind of a watershed moment, but I'm not sure if it went in the direction that a lot of people thought it was going to go in. So there might be framed to be a lull. Some might call it a demobilization. And I wonder what you think about it. Do you think that the downshift was simply coincidental, that it was going to happen, that all the outrage and the mobilization eventually was going to be, sort of downshifted, and it just so happened that the height of it came when the president spoke, but these things were not related? Or is it a reflection of having symbolic recognition is pretty much all people were looking for, and it had the effect of saying, well, people got something? Or is it what he said? What his agenda was, the way he said, I'm not indicting the law, the jury, the judge, but it would be great if we told black boys that we loved them.
I think the answer is actually all three. One, to go to the last point you made, definitely the bar is so low in terms of what people expect to solve the problem. So they wanted Obama so badly to empathize. Well, he did. Oh, thank God. And on top of that empathy, you do have a position that's being taken, and again, it's not, this is even within the African American community, that the real problem still stems with the behavior of black boys. Now, all the statistics show that, among young people of color, young African Americans, crime rates are lower than ever, just low. But it doesn't matter. There's still this problem because you can always point to Chicago and talk about the murder rate. And so you have to solve that problem. So that's one thing. And I'm not saying that it was a conspiracy or anything, but it really has to do with the lack of a movement in the United States. The other thing is that, very quickly, there's a sense that we've experienced a series of victories. And I'm not sure if that's true. One victory, of course, and I say victories in quotes, is the recent court ruling on stop and frisk. That every time there's a victory, there's a sort of sense that we don't have to sort of fight again. So stop and frisk is one. Another victory, which I don't think is necessarily a huge victory, but when de Blasio got the Democratic nomination in New York, people saw this as a turning point, like the new left. This is the same mayor who thinks that Bill Branton should be the model, who actually is not about to dismantle the basic police state in New York. But that's okay, because he's going to raise the minimum wage, which I think is good. I'm not against that. But again, there's that. And finally, you've got the 50th anniversary of the March on Washington, the kind of seizing of power of Reverend Al Sharpton, and the whole sort of the National Action Network becoming the mouthpiece in some ways for a very narrow agenda, which is only about trying to stop, eliminate, stand your ground, and not about the sort of massive continuation of forms of state and non-state violence. Now, when I say violence, I don't just mean violence in terms of guns. I mean violence in terms of mass incarceration, violence in terms of the defunding of schools, the building of prisons, violence in terms of the massive expansion of poverty, and the fact that, I can give you a long, long list. That these are the kinds of issues that are really fundamental, but the sense that we are on a momentum that's upward and successful, I think has contributed to demobilization of where we are.
And so along the lines of the kind of things that contribute to demobilization or more broadly limited mobilization is the way that some of these cases are framed, right? So, Addie, I knew that you had some thoughts about how the Trayvon Martin case has been elevated as exceptional against a backdrop of many, many, many cases like this, and importantly, how certain claims about innocence have circulated within that elevation. So what contribution or concerns do you think this reflects?
Yeah, thank you. So my thinking about this has sort of changed a little bit as I've watched the case happen. So I started working on a paper about self-defense right around the time the killing happened, and then I sort of watched the media responses to it, and I'm on Facebook, and I have lots of friends who agree with me, but a handful of kind of my crazy friends, and watch the videos posted sort of saying things that I thought were kind of shocking about how Trayvon Martin was really trying to make lean out of his Skittles and his soda or his iced tea, and I'm trying to figure out sort of how to figure out where people are coming from. And I think, so one of the things that struck me in the beginning is that this was an exceptional case because at least a lot of the media coverage around it sort of took up the story that Trayvon Martin was an innocent victim, right? So there wasn't any gun found on him. Most of the mainstream media depictions were about how he was just a little kid. And now you had pushback. You had pushback from some stories sort of suggesting this is actually a scarier picture of him. He was high, and that marijuana makes you want to fight people. So there was pushback, but a lot of the media coverage was about the possibility that he was an innocent victim, and what struck me in the beginning about that is that that's really unique, right? So we had a killing. I teach in Las Vegas, and we had a killing at almost in the same month that happened. A 17-year-old kid named DeMarcus Carter, and he was shot in the backyard of a home of a majority white suburban development called Summerlin in Las Vegas. So it's a really similar kind of neighborhood to where the Trayvon Martin shooting happened. And the media coverage was so different in that case. So there were a few stories in the paper about it. The guy was not charged. The idea, this is a defensive habitation type case, so he was probably, the idea was that he was going to break into the house. And I think in the end they found burglary tools maybe, but there wasn't any media discussion because there was no charges and there was no case. And what really struck me was the description in the paper. So there was this general public acceptance of Carter, who was a black man, as sort of a dangerous person. So there's this foregone conclusion that he probably was trying to commit a crime. And even if we're not really sure, it's likely that would end up being the story, so nobody's worried. So there was a passage in the paper where so this is a quote. During the interview with police, Carter confessed to several other burglaries. In one instance, Carter told police he stole a class ring from a home and gave it to his mother. When she asked where he got the ring, Carter told his mother, "I stole it from some little white boy," the report said. His mother, Virla Johnson, pawned the ring for $800 and gave the cash to Carter and his friend, the report said. Carter traded his mother marijuana for the money. Johnson, 41, the mother, is currently jailed at the Clark County Detention Center for probation violation. So the coverage of the case that happened in Nevada at the same time was just about the criminal record and the dysfunctional mother of this 17-year-old black youth who was shot, and there was no suggestion, no questions raised about whether he was intending to break into the house, what the evidence was, whether the prosecution was appropriate. So that was a contrast to me to the coverage of Trayvon Martin. And so I thought, well, this is an exceptional case, and maybe that's some of the reason why there was so much mobilization around it. The idea is that, this kid is innocent, and we can sort of point to the idea that he's innocent instead of just his death is kind of an inevitable, maybe a positive outcome because he's probably a criminal. That second discourse is what you usually actually hear about in self-defense shootings. So one thing is that the Martin case was exceptional, but what was sort of the most depressing reality, I think, at the end of it is after the Zimmerman verdict, I still heard people sort of saying, but this was so unfair because the media picked up on the idea that he was innocent and they didn't come up with these, there were other facts suggesting that Trayvon Martin might have been an aggressor. There might have been something not innocent about him. So people were still angry that it was a biased in favor of Trayvon Martin media perception. And even in the most supposedly biased portrayal of the victim, you still get an acquittal. So you can only imagine in the cases where there's no media outcry, sort of the most common self-defense type cases, it's all just seen as sort of an inevitability.
Mm-hmm. And so I have a couple more questions for the panel, but of course we want you all to join us in this conversation. So ready up your questions. I would say line up at the mic, but there isn't one. So I'm going to sort of start up this way and circle back around the side. So let me ask the two more questions, and you all consider what you'd like to throw in the mix. Sherod, I know that you have, first of all, some doubts about our conversation about the lull, so I want to ask you to step into that, and potentially to step into this. I'm going to ask you to put your hat on as the social scientist and the person who looks at institutions. And from your vantage point, what is the significance of this activity? What are the levers that you'd want to direct us to in order to help us think about avenues for transformation, either at the legal level or more broadly at the level in which these laws have been produced, or more broadly still at the level at which, as Addie talked about, the significance of the loss of life turns on a background narrative of who the person is. So we've got a real good sense of the problem. As a scientist, what can you tell us about avenues towards confronting these problems?
So let me first address your initial question, is whether or not we are experiencing a lull. And as we talked earlier, I think it may be a little premature to say that. One thing we know in the aftermath of the Zimmerman trial was a state senator, right, advocating for significant reform to Florida's jury system, right? So everyone, right, you are entitled, a criminal, if you're charged, you're entitled to a jury, particularly if you're facing a maximum penalty of 6 months or more. However, actually the size of that jury is left up to the states, and so the Supreme Court said there's flexibility. Generally, there has to be a minimum of 6. Right? Florida is one of those states where there is a minimum for a requirement of 6 jurors, unless it's a capital, unless it's a death penalty case. Right? But in the aftermath of Zimmerman, right, there has been some movement to expand Florida's juries to a minimum of 12 for a much broader class of cases, and also efforts to make the trial jury, right, and develop procedures to make the actual trial jury more reflective of the community there. And so that is something that has come out. Again, still in its preliminary stages, but we do have, right, some legislative rumblings of being important about that. And so that's one thing that may be a positive note that extends beyond the Zimmerman case there. Also, for those of you who might remember, there is this Jordan Davis case, right? Now, I think we'd be talking much more about this because the trial was slated to start last Monday.
So tell us a little bit about that.
Okay, so the trial was slated to start last Monday, but it's been delayed at least 6 months. So this was a case. This was in November. So Trayvon Martin was killed in February, right? So mid-February. So come November, Jordan Davis, African American, 17 years old, he's a junior in high school at this point, and he's in Jacksonville, Florida. He's in a car, it's Dodge Durango, with 3 of his friends. They're at a gas station, and they're playing some music. Michael Dunn, I think it's Michael Dunn, with the D, sorry. He drives up, he and his girlfriend's driving his car. They drive up to basically a gas station, and his girlfriend goes inside the gas station to buy some things, and at the same time, one of Jordan Davis's friends is, he's in this gas station as well. Davis and his friends have the music up in their car, and Dunn basically says, "Can you turn the music down?" First, the music is turned down, and then I guess there's some words exchanged between Dunn and Jordan Davis. Jordan Davis is in the rear. He's in the rear seat of the car, in the window, the car closely facing Dunn's car. So some words are exchanged, and Dunn claims that he sees a barrel or a stick come. Jordan Davis sees this through the window. He grabs his firearm out of his glove compartment, fires 5 shots into the car. And they're parked right next to one another. So Jordan, by this time Jordan's friend has come back, Jordan Davis's friend has returned, so they try to speed off. Dunn steps out of the car and fires 5 more shots as they are fleeing, and admits that he sees that the boys' heads are dug down, and he's firing because he says he's fearful that they'll actually return fire. His girlfriend then comes out, he speeds off, eats pizza that night, finds on the news that Jordan Davis was hit and killed. His the 3 passengers in the car were not killed, and then he actually flees to his home in Daytona. But fortunately, there was a partial license plate taken by one of the employees at the gas station, and then the police officers come and get him. Okay, so that's the situation there. Fortunately, you have witnesses. Not only do you have Jordan Davis's the 3 passengers in the car, but this was also at a gas station, so you had many other individuals who witnessed this as well. Now, at this point, Dunn wants to employ stand your ground. We'll see how that actually plays out as well. But again, I think with these situations, right, there is still, there is still discussion of these issues, and also there's the Marissa Alexander case, and so my time is up, but I can't talk to this as well. But this also, I think, is still keeping these issues at the fore and can build a positive momentum we need for structural changes.
So that's a hint for someone in the audience to ask about the Marissa Alexander case. Peter, I'm going to round it out with you. So much of the debate in our conversation has been about establishing whether there is, in fact, racial bias in the criminal justice system. And because that's such a heavy lift, we really don't spend a lot of time figuring out, so if a judge or a set of legal actors agrees, yes, you're right, there is what we think the remedy should be. So let's suppose that we have, you know, a fairy godmother. I call her Geneva Crenshaw. And her spirit occupies judges and political actors and policymakers across the region. They want to do the right thing now, and they just want to know what the right thing is. So what do we have to tell them about what the right thing is?
So this is an interesting problem. It's far from clear, right? When I have been faced, certainly with advocacy around racial profiling issues in Los Angeles and the Los Angeles area, figuring out what the right remedy is for a department, like what your ask is. You have, or I have had data that I think shows very powerfully that a department is engaged in racial profiling, that there are problems. What do you ask the department to do to fix it, right? And I think that is a very hard question. And if anybody during the question and answer has ideas, I welcome those. Put them into my prayers for relief. I mean, I think there are a few things that people have sort of asked for. One is I'll start actually with the Justice Brennan or the McCleskey versus Kemp, the invalidation of the criminal justice system. I have this sticker which was here, that we are all Trayvon, the whole damn system is guilty, right? That's the first one, throwing that out, right? Throwing the whole system out and stopping this criminal justice system from functioning. I mean, I think that's an unlikely solution, as much as there may be merits to it. What courts have practically done kind of falls into two categories of relief. One is to limit discretion, right? To the extent that the problem in the criminal justice system is that implicit bias infects the exercise of discretion. Limiting discretion may help that. So, for example, I think the difference in burden on a self-defense issue, whether the burden is on the defendant affirmatively to prove self-defense or the prosecutor to prove that no self-defense was used, right? That limits the juror's discretion in deciding whether self-defense was in play. And in policing, similarly, consent searches is something that we see horribly abused, right? The racial disparities in who is asked for a consent search is outrageous. Officers can ask for a consent search without any constitutional constraints, right? They're free to do so. But the idea that a department might require, as a matter of policy, reasonable suspicion before an officer asks for consent to search, right? That could place a check on racial disparities in discretion. The other avenue that courts have gone is to, I don't know whether to call this the kind of mindfulness, be present in your discrimination, or the Ben Franklin, you manage what you measure approach. But it's been to force departments to look their policies in the face, right? To collect data and publish data, turn it over to advocates, to in New York, right, to put cameras. Actually, this was present in Los Angeles too, to put cameras in cars in Los Angeles because the technology was not yet there to put it on the officer. Now it's there to put it on the officer. So that's what the court is doing. So that's another area. Then I think it's also just very briefly worth noting that a lot of advocates have kind of seen that the problem with the criminal justice system is really a reflection of the problem with society at large, and have looked outside the criminal justice system for solutions, and basically wound up with an advocacy agenda on racial equality in education. Books not bars. I'll give books not bars as the fourth possible remedy, and I think that is in some ways probably the long-term sort of answer.
So now it's your turn. And what I want to encourage is not just questions, but comments, observations, solutions. You're part of this conversation as well. So I'm going to take questions in sets of 3. And as I promised, I'm going to start up this way and go around to the other side. So right here.
Thank you firstly for being here. I've taught students, young students, and they've been extremely traumatized by this, as have I, and so I'm grateful to hear you provide some insight. Also as a future lawyer, I I was speaking to a lawyer who talked about the prosecution, Trayvon Martin's lawyer, and how they suggested that this lawyer did a really inadequate job of defending, of prosecuting the case. And I'm just wondering if you could provide a little insight into how the case was actually fought and how that led to this outcome.
Okay. Going up and around. Another question. Yes, right here.
So I'm from the university across the city, and last year 2 of my students were among the 6 students arrested in last year's racial profiling incident at USC, where LAPD officers made the tactical decision to send over 70 LAPD officers to break up the Black and Latino student assembly end of the year gathering, while ignoring the unregistered, predominantly white party across the street. And after an extensive traditional media and social media campaign representing these students of color as scholars who followed the letter of the law, only then were their charges dropped by the city attorney. So to the point that was made earlier in the panel, how does it take students who have reached that level in order to be depicted well in the media, and how do we overcome the inherent media bias that exists in terms of curriculum studies?
Yes, in the back.
First, I want to say, Professor Crenshaw, I really like your hair.
And Professor Ochet, yours fly as well.
So I have a comment and a question. My comment is I think that the panelists are all talking about the way in which the criminal justice system reflects this idea of the impossibility of Black victimization, either from judicial or extrajudicial violence. So we have that in the context of Trayvon Martin. We see it in the case of Marissa Alexander and C.C. McDonald. So if you all can, maybe talk about that. But the question I have is about a different aspect of the Trayvon Martin case involving Rachel Gentel, who was sort of the star witness of the case, whose testimony was essentially disregarded by the jury. If you believe some of if you've heard some of the accounts from jury 47, I think it was. So I wanted to put that on the table, this idea of the disregard of Black veracity and how that reflects sort of a long-term orientation of the criminal justice system that began with formal exclusions of Black witnesses from providing testimony in court, precisely because of this idea that Black folks don't tell the truth. And so I was wondering if you could talk about that.
Okay. So, great set of questions. And let me add to the disregard of, or the doubt of Black veracity, add to that other kinds of disregarding that we see. So the disregard of Black pain, the lack of I guess, sort of representational capital, which is, the behind the story about USC. So all of these sort of racial deficits that we see playing out in the way victimization is seen, the way threat is seen, the way veracity is seen, what is the way in which this is playing out, and what are some of the responses that we can have or should have to them. So I'm going to start with Sherod, because there was a Marissa Alexander question somewhere buried in that, so you can use that as a jumping off point if you like.
Okay, I'll try to share this one with Abby. Is that going to work?
Yeah.
Okay. So I'm going to do my informal poll, so just please indulge me. By show of hands, who's familiar with the background of this Marissa Alexander? Okay, fair amount. Okay. So I'm still trying to get my head, because there's different accounts around kind of the true factual landscape. But there's a situation, at least the facts as the way the court has accepted them, is a situation where Marissa Alexander had been in a very abusive relationship, and she had a restraining order against her estranged husband. And while they were separated, she actually came to their home that they lived in together to retrieve some of her things. He physically attacked her in the home. Her car was in the garage, so after this attack, she goes to the garage. It actually gets a firearm, re-enters the home, and there's some questions over whether or not she could have actually left the garage, because whether it was broken, so maybe there wasn't an avenue to leave. But she fires 2 warning shots into the wall. One of the shots goes into the ceiling, and her estranged husband there Rico Gray, I believe was his name. He had 2 children from a prior relationship. So she, under Florida's law, if you are engaged in certain felonies, aggravated felonies, and you use and shoot a firearm, there's a mandatory minimum of 20 years. She was offered a plea agreement, and she didn't, I think, around 3 years, but she asserted self-defense and also wanted to withstand your ground. Anyway, she was convicted and was serving 20 years. Now, her case is on appeal because of a technical issue with the jury instruction, which I won't get into at this case, at this point. But part of the appellate strategy is also to, again, try to get the stand your ground self-defense applicable to her situation. So that's the situation there. Now, I'm a former public defender and former capital defender, and so I've always kind of think of these issues in different, in different ways. And so I'm real cautious about stand your ground in general. I think the issue with the Marissa Alexander case, and something that Maddie and I talked about, has to do more with the problem with mandatory minimums and the problem with the underuse of executive clemency. In this situation where the letter of the law might convict you, but the spirit of the law, you shouldn't be punished that severely, that's when you have your governor commute your sentence. Okay? And so that's the way I think about that issue. So I'm not fully on board with the stand your ground should even be more expanded to cover to Miss Alexander, but I do believe that she was wrong by the system in that regard. But,
yeah, so every time I have spoken about the Trayvon Martin case, there is a question about compare it to the Marissa Alexander case, and usually it goes something like this. So the conversation is like, well, Marissa Alexander is a black woman who didn't get to take advantage of it, and George Zimmerman is a non-black man who did get to take advantage of it. And then someone else writes an article or suggests something that says, but it wasn't really in the Zimmerman case, and actually the facts are really different in the Marissa Alexander case, and it's apples and oranges. And I do think it's apples and oranges, but the Marissa Alexander story is a sort of a different race story that I want to tell about it. And it, I think, goes a little bit to the question about the impossibility of black victimization. But this is about domestic violence and self-defense law. And I was talking about how stranger self-defense law has been expanded so that it's easier to claim self-defense against a stranger. But where it's not easy to claim self-defense is in a domestic violence situation. And it's pretty clear to me that that is a story where domestic violence was involved in some way. And it's not so much about whether she could claim stand your ground or not, but she, I don't think, could really claim self-defense, and this is true about women who are trying to fight back against batterers all the time. There are all kinds of reasons why you can't doctrinally claim self-defense, and one of them is that the threat maybe isn't imminent, so there might not be someone trying to kill you right then, especially if you have a gun and your husband doesn't have a gun, then it doesn't look like an imminent threat. There's also the retreat issue, so if you could have gotten out of the house instead, then you had another way around it besides killing your abuser. And the reason it's a story about race, too, though, is black women have exceptionally high rates of domestic violence victimization and also often end up in prison for killing their batterers. So it's a different kind of a story about how race fits into self-defense law. I think it's no less important and it's no less related to these questions that have been asked, but it's not an apples to apples comparison with the Trayvon Martin case.
Peter, do you want to say anything about the prosecution, the failures of the prosecution, the inevitability debate?
Well, I'm not sure that I do, because I don't do a lot of criminal law, and so I am reluctant to second guess the prosecution in the case. But I do think, I think the prosecutors were. It's easy to second guess, I think. I did actually want to touch briefly on the USC issue and just say, your question was essentially, is this what it takes, right? And the answer is so clearly yes, right? That police are deployed every moment in the city along lines that are informed by racial presumptions, right? And for the vast majority of the occasions where the subjects are not USC students, right? Nobody ever notices. In much the same way as in the vast majority of situations where you do not have quite as compelling a case as Trayvon Martin nobody ever notices, right? And I think, you know, that speaks to the power of these cases and as opportunities to try to change the dialogue, either through legal means, by bringing cases. You know, I certainly believe that in doing impact litigation, that the power of the narrative of the case is you know, much as determinative as the law, and also trying to change the discourse kind of more generally.
So Robin, I want to bring you back in to comment on any of this, and in particular, what can you tell us about what happened with Rachel Chantel? I mean, one of the most painful things about that whole moment was the way that intra-racially there was discourse around her that was very painful. So what do we attribute that to? And I guess more broadly, to the extent that gender is playing a role, there's an absence of discourse about how black women, young black women, are situated in ways that obviously contribute to the victimization of the community, but there's not a mass mobilization around that. So of many things that you might say, what might you say?
Let alone the large number of women who are victims of state violence and extralegal violence as well. Actually, let me try to answer that question by linking these two questions: the question about black veracity and black pain not being recognized, and the question about the USC students and Rachel Chantel. And that is that, and I should preface this by saying that to write this down, on October 30th, David Leonard's actually coming to UCLA to give a talk on called The Presumption of Innocence, which is about how is it that white people are always presumed innocent, and yet in this particular case we're talking about African Americans, black people, are presumed to be guilty. And what's interesting about the USC case and the question that you had raised and Rachel Chantel is that for African Americans in particular, but I think for all people of color, every case of black victimization requires proving that the person is actually of good character and good standing. So-and-so was Latasha Harlins, you know, killed. The main point that people were making was that she was a good student, she was an honor student. Of course, you know, the truth is more complicated than that, but the fact is that information has to be suppressed for her for justice to be justified. The same with Trayvon Martin. The emphasis was on he's a good kid, and then the challenge, the pushback on Trayvon was all about trying to say, well, if he's not a good kid, therefore he's presumed to be guilty. Presumptions of innocence always is about good behavior. USC, the fact that these are students at the university and they're not out there selling drugs or, you know, just out there hanging out. Well, what if they were just hanging out? What if they're not university students? What if they were terrible students? What if they were all convicted felons? They still should have the right to the protection of the law, but that's not the case, right? And so with Rachel Chantel, because of these assumptions about how she comports herself and what she knows and what her limitations might be, there's a way in which veracity is not available to her for that reason. You know, if she were a different spokesperson, that's why the word articulate is always used for black people. Mm-hmm. Notice that. Always. You know how many times I've gotten that? You know?
But Robin, you are so.
But it's really, and this is someplace we really have to begin to change the discourse, because you go way back, even Emmett Till. There was a way in which there's a kind of discourse around Emmett Till saying that Emmett Till was actually a good kid. Why do we have to prove goodness as a way to justify protection of the law when you're a person of color? But, you know, you could be like any typical white frat boy, you know, drunk half the time, committed all kinds of felonies for which you walk, and you're presumed to be innocent, right? And so I think that's part of the discourse that we're up against.
I'd like to add something to
And then Addie wants to add something.
Oh, did I jump line? Okay. Yes, I'd just like to add something again, tying into Professor Ocean's question about black pain. So we also have to look at the decision makers with respect, again, there's a tremendous amount of discretion, as Peter mentioned earlier, with respect to not only policing, but charging and sentencing decisions, right? And so we look at some of the best available evidence, right? 88% of state prosecutors are white, right? And this is white non-Hispanic, okay, right, white, right? 88%, just in case, right, let's be clear what we're talking, right? 88%, right? In death penalty states, that number is 97%.
Wow.
97, right? Right, nationwide, 90% of state and federal judges are white, right? 90%, right? So I'm thinking about a line, and I'll take some lyric, a little rap lyric here. Yasin Bey, also known as this is for you, Priscilla. Yusuf Bey, right? Their song Black Star said, I find it depressing. There's never an in-between. We're either N-words or kings. We're either B-words, or queens, right? There's no middle ground, right? You either have to be pure or you're just completely defiled and dirty. And that, a part of that goes to, right, the perception of decision makers, right? What are the presumptions that they're entering these processes in? So I think it's very important. And I also want to tie in on something that Peter said earlier when he mentioned the McCleskey case, right? He said obviously there was strong statistical evidence that if you killed a white person, all right, if it was a white victim, right, you're much more likely to not only be noticed for the death penalty, but also sentenced. The ratio is about 4 to 1, right? So you were 4 times more likely, okay, to be sentenced to death if you killed a white defendant as opposed to a black defendant. Now, I've done my own McCleskey study looking at the same jurisdiction in Georgia from about 1993 through 2000. McCleskey looked at 72 to about 78, 80, just the 19, right? So that's kind of, so we're looking many decades later, and that multiplier was about 3.9. So, and McCleskey was about 4 points, it was like 4.3 times larger, and then my more recent study was 3.9. So over all these years, you basically have the same, right, the same, not only the direction, but the magnitude is the same, right? So then I'll close with my last most death, right? He said the value of a black life is treated with short worth, and that's what we have.
That's right. Addie?
I should have gone first. That's hard to follow. So I want to link this conversation about sort of the presumption of guilt back a little bit to law, and to say that one thing that happens, and I think we have to be conscious of in how it happens in the media and then also in courts, is that it moves the discussion from what happened at that moment to sort of the background history. So in the excerpt I was reading you from the DeMarcus Carter shooting in Nevada, it was a story. There was never a story about what happened in the moment he was shot. Now, self-defense is supposed to be about what happened in the moment you were shot. It's about that moment and that decision. And all that happened was a story about his dysfunctional mother, his mother being in prison, his criminal record in the past. And so what I think is going on there is it's a presumption of guilt in the moment often, but it's also sort of a presumption of inevitable guilt. So the idea is that all blacks are sort of headed for criminality eventually. So maybe at that moment there was nothing going on, but we don't even need to talk about that moment, because even if it was a wrong self-defense shooting, probably this guy wasn't going anywhere good, right? He had a mother in jail that he traded money for weed from. I mean, this is not someone that we need to be worried about that he's dead. And that there's a slippage that happens in our discussion of the cases where, you know, the victim ends up being on trial and sort of the history of the victim. And we need to be more careful about that and about cabining it in to the discussion of the case. Not to solve everything, but it's one way to push back against that.
So our panelists have been asked to each give a 1-minute summary and sort of benediction. But prior to that, if you all promise to make your questions 30 seconds, because we're out of time, but I want them to be able to hear your questions as they prepare to give you their parting thoughts. So I'm going to go around, I'm going to collect them quick, I'm going to collect them fast, and then I'm going to turn it over to the panel for conclusion. So what's in the back there? Yes. Yes, of course.
enlightening program at point. Robin, when you were speaking about the armed self-defense units, maybe during the Jim Crow period, what was going through my mind was, and the disbanding of them, was the lynchings that were going on at the same period, including 7,000 black people being lynched. And somebody raised the point about the federal government. And the federal government, it wasn't just these white folks, it wasn't just these, sheriffs in the South or whatever. The federal government green-lighted those lynchings. And you go back to, Dred Scott and a white person, there's no rights that a black person has that a white person is bound to respect. And then you go up to these lynchings, and then you come up to Emmett Till, you come up to today, and you look at an entire sweep of history of the oppression of black people, and then you look today with this criminalization. And I think there's three broad things. One was the history that you all brought forward, but also the trial itself. The Batson decision, which some of you may know, it was supposed to protect blacks from being on the jury. It was used to protect whites from being on the jury in this particular case. I was just writing profiling. You weren't allowed to say racial profiling during the trial. These are more questions about, what do you make of this? Look,
Okay, that's your 30 seconds. we got you.
I just had to say one thing. This last point on the Trayvon and your point, Peter, about this, which I thought was just a wee bit faster. You did say unlikely. You were an absolutist about it. Look, can be read in a lot of different ways. The whole damn system is guilty. You were right. It wasn't just the law. It was the state. It was the media that protected Trayvon. That's why the whole damn system is guilty. Now, if the implication is the system needs to be swept away, and you want to read it that way, which, it can be read different ways. I believe that to be the case.
Tick-tock.
And if people want to find out about that, there is another program. It's the 17th of October Academic Advancement Program, Bob Avakian, 1 hour, and a Q&A after it at the knees.
So now we get to it. Okay, great. All right, over here. Thank you.
Thank you very much.
So there's interesting commentary about where the NRA was and wasn't during the Zimmerman case, and I'm wondering how we can disarm, pun intended, this NRA argument about the gun control laws and how it relates to the history of the black community without denying the history, Professor Kelley, that you talked about of these community self-defense. And so my question is, how do we deal with this discourse in light of the real history?
Okay, great. Thank you. Last, absolutely quick, fast.
And I feel like this, a lot of times we're talking about criminalization, criminal justice system, we make it a black-white issue. So I was wondering if maybe somebody could chime in too, where I don't think the black males are person in this society. How do other people of color also undergo the same things? Because if you see the panel and if you see the discussions, it's just very black-white. And I feel like given the media, it's always this black-white binary, and maybe people of color that are not black just get left out as if they're not victims of these same systems. So I just thought maybe somebody can throw that in there to make this not just the black issue.
All right, so let us start in the same order that we went. So I'm going to start with Peter. Peter, pick up any of these and give us your action item.
Sure. I think I will respond to that last point by saying that I do think it's beyond question that this is not a black-white issue, and particularly in areas in LA where you see Latino gang members, as kind of the same type, right? The same trope. I think that is absolutely true. My hope is that events like this, right? The national attention on this. This is perhaps also a little facile point, but this will catalyze something, will cause us to examine what it is in the criminal justice system that we we see failing and how to fix it. But I do think that there is a great responsibility borne by the people in this room who are advocates, who are training to be advocates, to figure out not just how to convince the country, the institutions of power that there is a problem, but to figure out how to fix it. So,
Sherod, quickly.
Okay, so 2 quick points and sort of what can we actually do on the ground. One is, actually, I mentioned earlier statistics about the lack of diversity in prosecutor's office, but a lot of public defenders is not that much better. But one is become involved, right? Become prosecutors. I'm a public defender, but we need different voices, different perspectives. So become interested in the prosecution or defense. That's the one thing I would say. And the other thing I would say is, with respect to, when we think about felony, right, we talk about ex-felons, we think about felony disenfranchisement. We're always talking about voting. But this also plays with respect to juries. And most states, right, have an eligibility requirement is that you can't be an ex-felon unless you've had your civil rights restored, which actually is very complicated that many states make it, right? You can't be currently under prosecution. You can't currently be even with special misdemeanors that deal with quote-unquote dishonesty. And this is another way in which many people of color, particularly when we have over-policing and over-criminalization for nonviolent crimes, and communities of color are excluded from jury service. So.
Thanks. Addie?
Okay, I'll try to be fast. So first of all, to the question about the black-white issue. So I work mostly on Indian issues, Native American issues, and in the jurisdictions that I study, Native youth probably have the same or higher rates of disproportionality in the criminal and juvenile justice system as blacks. So it's definitely not a black-white issue. Professor Oshin mentioned the prohibition against testifying. So historically, blacks couldn't testify against whites, neither could Chinese people, and neither could Indians here in California. But that is not to say that I don't think we should be talking about blackness here. So the presumption of criminality and the sort of presumption of guilt and the media coverage and the way that we've talked about it here is a story about blackness. And I stopped actually talking about race when I gave these talks, and I started talking about blackness because that is where the story starts. It doesn't mean it doesn't affect other groups, and sometimes the dynamics for other groups are a little different. So the disproportionality I see with Native youth tends to center around getting arrested more often for offenses that have to do with being drunk, for example. So it's not the same story. The story is still there. We should be talking about it, but that doesn't mean that I don't think in this conversation blackness needs to be centered. And then as to what we should do, we've got to stop talking about intent. Again, with the juvenile justice example, so there is a federal law that requires states to monitor the disproportionate contact of minority youth with the justice system. States have tried to do this, and then people sit in a room saying, well, maybe they're just more criminal. So collecting all the data doesn't really do anything. And then even with racial profiling with sort of police cases, we try to find this smoking gun of like the police sitting in a room recorded in New York saying stop people just because they're black. So basically, unless we can find that race alone and intentionally was the reason behind something, we sort of can't get anywhere. We have got to acknowledge that race is always a factor, and it is always one of many factors. And so that means, one, that we need to be careful. We need to monitor the effects in citizen self-defense cases like we have tried to do in police cases. And then we need to be careful about expanding discretion and other legal loopholes, basically, where we have concerns about this. And then we just need to keep talking about it. So even where the judge says don't say racial profiling, there are other ways to talk about race in a case. And maybe that's something that the prosecution could have done a little bit differently.
Thank you, Annie. Robin.
Okay. Very quickly, on this question of, I never say black-white binary, because binary assumes equality of power. It's hierarchy, it's oppression. Racialization actually works, and in fact, there's a lot of things that we could talk about. The fact that many of those who were identified and profiled in New York, for example, I know I'm supposed to be home. Arab and South Asian populations, for example. Certainly there's a long, long history going back to genocide of indigenous peoples, to border policing, to, there's a whole history of police, state violence, and other forms of violence. But I also agree with Addie that, in some ways, some of those discussions have actually evacuated blackness, because in some ways, even the framework of certain forms of violence end up connecting to your relationship to blackness. And that's why, even in terms of attacks on people considered sort of either alien or Arab or terrorists, there's a way in which the machines themselves were established in the post-Reconstruction period. Now, very quickly, in terms of what to do, I want to just quickly address this question. I don't know if it's, I would argue that it's not so much violence as a strategy as much as trying to reduce violence through forms of self-defense and monitoring. And I think we have to return to that. One of the things that Akinele Umoja argues in his book is that in those counties in Mississippi where there were actually armed self-defense groups, violence was reduced. There was less violence. I'm someone who's I don't have any guns. I don't want to carry any guns. I'm not interested in guns. But the idea of organizing, of direct democracy, of people actually outside of the apparatus of the state to monitor the state, to participate, to police the state, to participate in ways to protect themselves as a community, that is necessary. We need to return back to that. And it's not necessarily black communities alone, but anyone who wants to participate in the protection of the people, through people's assemblies, through protections, in forms, and whether it's armed or not armed, I think that's necessary because right now, as much as I love courts and the law, they can't work fast enough. And they certainly can't be, I'm not against that, but I'm saying in addition to that. So.
All right. So our goal was to address many of the distortions and arguments that obfuscated, confused, and denied the racial contours of the case. I hope we lived up to that. We promised to offer some concrete proposals for capturing the moment. I hope we lived up to that. And I hope that in the same way that Emmett Till lives on in the activism that his tragic death inspired, that Trayvon Martin will also live in a better future made possible by our informed advocacy. For tonight, I want to thank our panelists, Sherod, Peter, Robin, and Addie for their insights, their thoughtfulness, and their guidance, and thanks to all of you for sitting with us and having this conversation. Thank you and good night.